Hello, my name is Earl McCoy of McCoy Law in Lafayette, Indiana, and I'm here today to talk to you about 4 reasons you really need to consider filing to establish paternity if you are father of a child born out of wedlock. Now, you may have already signed a paternity affidavit at the hospital, but you need to understand what that really does and what it really means, because it really doesn't mean much. It does establish paternity and create some obligations, but it gives you no rights really at all. So again, we're going to talk about 4 different things. The first one is any statute of limitations or risks that run against you because of delay. And there are some very significant risks that run against you because of delay. Another is, what exactly does the paternity affidavit give you? Does it give you any rights? It says it does. Or does it just create obligations and give you no rights at all, or no enforceable rights? So we'll talk about that. Another huge thing to consider is the back child support obligation. So we're going to talk about what happens if you don't file a paternity action as quickly as you should in terms of child support. And then the last thing I want to talk about is how, filing it, even if you and mom are still together, can give you a head start on doing things the right way in the event that your relationship ends up breaking up later. And it's important to know that this video is aimed at why a man should file a petition to establish paternity. The 4 reasons that I think are hugely important for a man to consider. A woman doesn't need to do that, because a woman, when the child's born to the woman, everybody knows that she's a mother. That's not the issue. It's a question of who's the father. So in that regard, establishing paternity is not as important for the mother, but it is best to file a paternity action for any child born out of wedlock, whether you're the mother or the father, because it truly protects both sides. Having a court-ordered paternity order or decree of paternity is going to protect both sides. It's the right thing to do. It's what's best for the child. So it should happen in every single case. Many times it doesn't, because people don't understand the ramifications of failing to file a petition to establish paternity. They think, hey, I signed a paternity affidavit, that's good enough, right? No, not hardly. Not for either side, really. So we're going to talk about that a little bit. First thing is, like I said, statute of limitations and other deadlines that apply. There is a statute of limitations that applies to paternity actions. You must file a petition to establish paternity within 2 years of when the child's born. That's not really an ironclad rule. It is, dad wants to file or mom wants to file more than 2 years after the child was born. They really can't do it in their own right. They can get around it by filing on behalf of the child, and that's what all attorneys do, right? I'm really just telling you this in case you're trying to do it without an attorney. You don't want to file it the wrong way. If you file more than 2 years after the child's born as the dad and say, I'm the dad, I'm filing, I want to establish paternity, or the mom for that matter, you'll be barred, because you can't file more than 2 years after the child's born. You have to file on behalf of the child as next friend, is what it's called in Indiana, on behalf of the child. But that's only one consideration. The other problem is there are other laws that come into play, right? You have a general statute of limitations on filing paternity, but there are other laws. One of which is, if you've signed a paternity affidavit, the affidavit says you only have 60 days to ask for DNA. And if the DNA proves that you're not dad, you only have 60 days to file to disestablish paternity, because you have to do that. If it's more than 60 days, the judge may not give you a DNA test, or may not allow you to disestablish paternity. So that's a very significant deadline, a 60-day deadline from the time the baby is born. All right, or at least from the time you sign the paternity affidavit, which has to be signed within 72 hours of the baby's birth at the hospital for it to be valid. All right. In addition to that, there's another law, again, not really a paternity law, but it comes into play, and I've used it against people before. So, on the one hand, you have 2 years to file to establish paternity, and sometimes people wait longer, 10, 12 years to establish paternity. But if mom is in another relationship and she, say, is married to another individual and he decides to adopt, there's another law that comes into play that it's not used very often, but I've used it to terminate somebody's parental rights before. And that law is Indiana's implied consent to adoption law, or what we have as our version of an abandonment law. And that law says that if you go 12 months, a year, without having any significant contact with a child, or 12 months consecutively without paying any child support, and it doesn't matter whether child support was ordered or not, right? So you haven't gone to court, you have not established paternity, you haven't been ordered to pay child support, doesn't matter. In Indiana, you have a legal duty to support your offspring. If you haven't paid any support, given mom any money that you can document for 12 months, you've impliedly consented to an adoption. And it doesn't even have to be the most recent 12 months. So I had one case, for example, where my client, mom, didn't allow dad to visit, didn't allow dad, didn't have anything to do with dad. She was done with him. The relationship was over. It was an accidental pregnancy. She met somebody else. They got married. And 18 months after the child was born, dad filed a petition to establish paternity. Biological dad. Which I guess we don't really know because paternity didn't allow to proceed. Even though he filed within the 2-year statute of limitations, it was 18 months from a child's birth, he hadn't visited and he hadn't paid any support, voluntarily or otherwise. And so we immediately filed a petition for adoption and alleged that he had impliedly consented to the adoption. And the court agreed. They ended up saying, you know what? You got 6 months to get this adoption finalized. Dad's impliedly consented, so he slept on his rights, and now he doesn't have a child anymore because we did get the adoption to go through, and dad's rights were terminated. So it's incredibly important. I wouldn't wait 2 years, even though there's a 2-year statute of limitations. I wouldn't wait 1 year because I could impliedly, accidentally consent to an adoption. I wouldn't wait more than 60 days because you may not be able to disestablish paternity after that point, even if DNA shows that you're not the father. So that's very significant. Now let's take a look real quick. Come over here. I want to show you the actual paternity affidavit so that people realize, because they don't read what they sign anymore, right? I mean, we're all guilty of it. I'm guilty of it. I think the AT&T cell phone contract I signed was like 13 pages on a screen. They're like, here, sign here. Nobody reads it, right? We should. Everybody should, but particularly a paternity affidavit. So I'm going to show you right now what this thing says. Look. Bold, you should not sign this form if you're not sure you're the biological father, if you're not positive. Now, that's incredibly important. And this is a bonus tip. Mom, don't be mad if dad asks for a DNA test, right? He may be asking just because he's watched this video, or he may be asking because he's met an attorney like me that encourages him incredibly strongly to ask for DNA. The reality of life is this. Mom can know whether somebody else could be the father or not. Dad never knows. Dad can't know. Dad can't know because he's not with you 24/7, right? And if you're not tied together 24/7, held in a cage, you just don't know. Anything's possible. And you can't go by eye color, hair color, skin color. That's bogus. You can't look at a child and be like, oh, I'm sure. No, you can't. And I'll tell you why you can't. Because I've had cases where my client's dad has been sleeping with their girlfriend. So, I mean, you just can't tell. Anything in that DNA chain could lead to those same results, and you just don't know. So in Indiana, my advice is, look, get a DNA test no matter what, because you are going to be responsible for this child, for the child's entire life, all the way through college expenses, maybe beyond, right? Not to mention the bond and affection you're going to develop with the child. And what would it do to the child if you found out later you're biologically not the father, so now maybe you act differently around the child. The child didn't have anything to do with it. This poor kid's just a victim of your guys' behaviors, not anything else, right? The child has no control. The point is, get a DNA test. You don't want to find out later that you're not the father or might not be the father, because even if you do find out later you're not the father, if you haven't done things on time, like we discussed earlier, you're legally dad anyway, and you're going to pay for college expenses, and you're going to pay child support, whether you visit with the child or not. That's the reality of it. So get a DNA test, and mom, don't be offended. Just because he's asking for a DNA test does not mean he thinks you're a tramp. He might, but he might have just talked to somebody like me. He might have watched this video. He might have realized, hey, it's real easy. You don't have to get stuck. You swab the inside of somebody's cheek, and you find out whether you're dad or not. Plain and simple. All right, so back over here. You should not sign this unless you're absolutely positive you're dad, and you can't be. I'm just telling you, you can't be. Mom can be sure, but dad can't be sure. But then you look down at what this does, and I'm going to highlight this portion down here. All right. All this really does is create an obligation to pay child support. That's what this form does. This form legally makes you dad. Once you've signed it, you're dad. And now you can be sued for child support by mom or by the prosecuting attorney's office in the county for child support services through the 4D, what's called the 4D program. So all this really does is create an obligation to pay child support. It says down here, the father will have parenting time as outlined in the parenting time guidelines, unless court rules differently. But that's really not true because you can't enforce it. It's completely unenforceable unless you have a court order that says you have guideline visitation. You can't get contempt. If you can't get contempt, it's not enforceable. It's not like the police are going to enforce this in any way, shape, or form. All you have here is a document that says you're dad. If the prosecuting attorney files something, they're only going to file a petition to establish child support. They're not going to give you any visitation rights. You would have to counterfile to get some kind of enforceable visitation rights. So there's nothing here that gives you anything enforceable in Indiana at all. It does say that you have a right to withdraw or rescind this, but only within 60 days of the date of signing the petition or the affidavit, and you must do so if you find out with DNA. DNA comes back, proves you're not dad, you have to file within that 60 days to disestablish paternity. And that's true, it says here, even, and it's bolded and underlined, even if the genetic tests prove you're not the father. So there is one carved out exception in Indiana because, I've warned people about this for years. One of the problems is you can say, look, I'm dad, I'm going to do this, I'm going to sign up, and then later you're trying to get your visitation rights, and at some point, whether it's in the heat of an argument or whatever, mom pipes up and says, well, you're not even dad anyway. And you're like, yes, I am. Yes, I am. I'm dad. No, you're not. Yes, I am. No, I'm not. Let's get a test and prove it. Okay. So you get a test. Test proves you're not dad. Doesn't matter. You're still legally dad. That test is not going to relieve you of your obligations at all in Indiana, except for one little exception that's been carved out in the law that says if you happen to find out completely by accident as a result of a medical emergency, then you can terminate your parental rights. But you can't terminate your parental rights if you just decide later to get a DNA test and prove you're not dad. That's actually in Indiana, the case law calls that bastardizing a child, and Indiana is not going to bastardize a child in that situation. So unless you happen to find out completely by accident as a result of a medical emergency down the road that you're not dad, you're going to be dad even if a DNA later says you're not. And that case that came down initially was a sickle cell case, and the doctor, I don't remember now if the dad had sickle cell or child. I think the child did and dad didn't. And so he's talking to the doctor, and the doctor's like, you're not dad. What? You're not dad? Well, I don't want to pay child support. I don't want to. Well, in that one case, they carved out an exception, and that's really it. It has not been expanded in the 2 decades that I've been practicing law. All right, so back to the form. This other part of the form right here talks about establishing joint legal custody. Establishing joint legal custody. Well, that sounds good, but it's really not. All right, what that does is it gives you a right to share in decision making on major medical decisions, educational decisions, and religious decisions. But if you've just signed a paternity affidavit, mom has primary physical custody. And if the two of you don't agree, mom trumps you anyway, so you really have no say. You just have a right to tell mom what you think, I guess. And that's it. No enforceable right at all. Now, what that will do for you is it'll hinder mom from getting the child back from you by calling the police. Because if you haven't filled out the joint legal custody section, then mom has sole legal custody of a child born out of wedlock. Until dad establishes something in court that he is actually dad, he has no rights whatsoever. So mom inherently has sole legal custody if that section is not initialed and signed by both parties. That means if dad has a child in visitation, then mom says, I want the child back. Dad says no. Mom can call the cops, and you're either going to give the child back or you're going to go to jail, because you're going to go to jail for committing a crime called interference with custody. The problem for mom is if she signs this part and doesn't get a court order that says who gets what in terms of parenting time, then you now have two parents that both have joint legal custody. Although mom's primary, the court, if you call the cops because of a visitation exchange or a parenting time issue, the cops are going to say, look, it's a civil matter, call a lawyer like McCoy Law, take it to court, but it's not a crime. We're not going to deal with it, right? So by mom signing this section, she can give up some power in a future custody or a parenting time fight on like a weekend or something, but not an overall custody fight. All right, so that's an issue. But even if you sign this section, you both initial, you sign for joint legal custody, it says right here, let me find it. All right, if you agree to share joint legal custody, you must submit to a DNA test by an accredited lab and submit the results to the health department within 60 days. Otherwise, guess what? It reverts back to mom having sole legal custody. That's it. So you don't get the DNA test done. Now mom's back to having sole legal custody, and you have no rights whatsoever, at least no enforceable rights, right? There's some reference to the guidelines in there in terms of parenting time, but it's nothing enforceable because there is no enforcement mechanism without a court order that gives you the enforceability. You have a court order, if somebody denies or violates a court order, you file contempt, now you have some enforceability, right? But this gives you nothing other than an obligation to pay child support. No enforceable rights. And don't get me wrong, paternity affidavits are a good thing. It does establish you're legally dad. The child would be allowed to inherit from you. There's a number of other good things about signing a paternity affidavit, and I am not suggesting that fathers should not sign paternity affidavits. I think they should. They're a great thing. You do that, you get your name on the birth certificate right then and there. Saves a step. My only point here today is you have to either file on your own or hire a firm like McCoy Law to file a real paternity action in a court of law to really get some rights, create some rights. And I'm not talking about taking a child away from mom. I'm just talking about making sure that you are recognized fully as a parent in every way, not just an obligation to pay child support. All right, so now let's talk about child support and what can happen if you don't file paternity quickly. Let's say you and mom are together or you're not. One of the biggest horror stories I have in my history is I had a guy who mom filed to establish child support 12 years after the child was born. Now, this dad had nothing to do with this child at all. In fact, the scenario is dad was living here in Lafayette, was out of work, had some friends over in the Danville, Illinois area, and he had gone over there for a couple of weekends looking for jobs, hanging out with friends, hooked up with this girl, like 2 weekends, hooked up with a woman 2 weekends in a row. After that, he finds a job in Lafayette, doesn't really go back there anymore, hears through the grapevine she might be pregnant, but of course he's thinking, man, I was only there a couple weekends, maybe it's not mine, maybe it is, but no harm, no foul, nobody's coming after me, I'm not going to have anything to do with the child. Okay, fine, I guess you can go that route if you want to. But then what happened is that mother later ended up on Illinois' version of welfare, and when you sign up for subsidized welfare, whatever, you sign up for that, you assign away your right to collect child support to the state. In her case, it was Illinois, but you do the same in Indiana. If you go in and sign up for welfare and assistance and you have a child, you assign your right to collect child support to the state of Indiana. Okay, so now they make you tell them who the potential fathers are, and if you name somebody and they come back, DNA says, no, that's not the father, you have to keep naming fathers until they find a winner. Because the state wants to get child support to reimburse them for the financial assistance they're giving you, all right? And you don't have any control over that. If you say, no, I'm not naming any fathers, they kick you off the program. You don't get the financial welfare, the assistance. So in this case I'm talking about, that's what happened. 12 years later, They initiate an action in Illinois through the prosecutor's office. It gets transferred to Tippecanoe County, Indiana. Of course, first thing we do is ask for a DNA test. Still hoping he's not the father. But it turns out he was the father. He was the winner, all right? DNA came back 99.99%. He's dad. So he's dad. The problem is now we got to establish child support. Well, by the time they caught up with him, when he first had the baby, he didn't even have a job. Then he had low paying jobs. By the time they catch up with him 12 years later, he has a very good paying job at Eli Lilly, making a lot of money. He also has a family and other kids. And now, guess what? We're establishing child support based on what he makes currently. So it's a good paying job. You don't get to go back and say, well, wait a minute, the first 2 years of the child's life, I was only making this. And then when the child was 5 and 6, I was only making this. It doesn't matter. And you may be thinking, well, why am I even talking about what it was back then? Aren't we just doing child support from here forward? No. In Indiana, child support can go all the way back to the date the child was born. Born 12 years ago, based off the money you're making now. Doesn't take long to figure out that that child support arrearage is going to be pretty darn high right off the bat, right? It's a scary proposition. So by gambling and saying, well, I'm not going to rock the boat, I'm not going to take somebody to court, you're not doing yourself any favors. If anything, you're hindering yourself, because if somebody decides to treat this as a 401k and come after you later for child support, they get to go all the way back to the date the child's born if they want to. The court has the authority to do that. It's a huge reason to file a petition to establish paternity, preferably within 60 days of when you sign the paternity affidavit, or 60 days of when the child's born. That's my preference. All right. The last thing I kind of said before was it also gets you ahead of the game in the event you and mom break up. You and mom stay together, get married, don't get married, whatever, great. It's not hurting anything to establish paternity and establish child support at 0 because we're together, establish parenting time by the guidelines. Then you break up, that's already in place. Then all you got to do is file a petition to modify child support from that day forward. You can't go back on them anymore. You can't go back 10, 12 years. That would be unfair anyway, right? So it just makes things easier. The other thing is, a lot of times when breakups happen, people may not have the money just on hand at that point to run out and hire an attorney quickly. So now we potentially have somebody playing keep away. We have somebody maybe moving out of state because there is no custody order. You can move out of state without any court approval. But if you have a paternity affidavit, not just an affidavit, but you file a paternity action and get a court order regarding paternity and custody, then at that point, sorry, just realized I need to do that. If you have an order, then the notice of the requirement that you file a notice of intent to relocate before you move out of state kicks into play, right? Those are just some of the protections that an actual paternity order will give to a father. But I said earlier, a paternity order is going to protect both sides. It's going to establish who the primary parent is. It's going to establish who has primary custody. It's going to establish how decision making is going to be made. Set something in motion ahead of time about what parenting time is going to be in the event of a breakup. Establishes child support. There's just nothing really bad that can happen from doing a paternity action right after a child's born. There are so many things that can go wrong if you don't file a paternity action in a timely fashion. So my advice is, if you know anybody in this situation, even if it's been 2 years already, even if it's been 3 years, that's better than 12, right? Contact McCoy Law or somebody like us as soon as possible. Get into court. Do this the right way. It's the best thing for you. It's the best thing for the child. It's the best thing for the mother. It's the best thing for everybody. So I hope you like this video. Hope you found some of it useful. There's a ton of other things I could talk about. I just didn't want to get out on too many tangents and have the video be, 45 minutes long, because I could talk for hours on this one topic alone. If you have any questions, please put them in the comments. It may lead to a future video to try to address some of the issues that you may be dealing with, or maybe it's something I can answer in the comments, or at least I can tell you whether you need to talk to an attorney quickly or not. Also, please hit the subscribe button, hit the little bell icon, get notification of any future videos. Right now, I intend to do a whole series of videos because I'm dealing with people every day that don't realize the ramifications of their actions. The purpose behind these videos is to educate you. That's what this is about. Because so many people just don't realize that, just having a paternity affidavit signed isn't a fix. In fact, that creates more problems for most people, starts deadlines for most people that don't otherwise exist. So the right thing to do is talk to an attorney as soon as possible. You can even file a paternity action before a child's born if you want. But you definitely need to file paternity action quickly, preserve your rights, and just provide some continuity for the child, right? Because at the end of the day, I don't know about you, but the court is most concerned about the child's welfare, not yours, not mom's, the child's welfare. And the court's order is going to help ensure that that child's welfare is protected. All right, thanks for tuning in. Click subscribe, share, click the bell icon, and keep an eye out for future videos. Thank you.